I'm going to talk to you about two cases. The first one has to do with some governance issues. It's an area of the law that I've taken really interest in strata property practice. So that's why I thought it's of interest, certainly to me. I thought it'd be interest to you. I've sort of subtitled it Some Tips About What Not to Do at a General Meeting. So Mr. McDonald was the opposition within the strata. And he took them to task over several issues. The case had to dealt with some ground level patios on some townhomes in Victoria. And that doesn't really have too much to do with the case other than it sets the background. There were three different meetings that were the foundation of this case. All of them dealt with this issue with respect to these patios. There is a 2017 AGM, 2018 AGM, and a 2019 SGM. So the case dealt with issues regarding notice of meeting, the use of proxies, and the conduct of the chair. And those are the things I want to take you through because I think they're very important and very useful when you're working your way through a contentious meeting. With respect to the notice of meeting, the court found that there were some problems with it. The first of which is that the notice, in the court's view, contained only the view of the Strata Council. In other words, the resolutions when they were drafted were very one-sided with respect to what the issue was and what the outcome of the matter should be. The court found that the notices didn't reflect Mr. McDonald's concerns and other owners who were in opposition. In the end, it was of the view that notices should be essentially neutral in their content. That doesn't mean that the council can't advocate for a position. It can do that outside of the notice package, but the court's view is that the notice should be as neutral as possible or alternatively present both sides of the issue. The other problem with the notice is that it referred to wrong sections of the Strata Property Act. So the lesson there, of course, is check, check, double check, triple check, and then have someone else do it. Because sometimes you just keep reading what should be there and it's not. Interestingly, the resolution referred to two different sections. Both were wrong. They corrected one at the meeting but not the other. And so the court, it was unclear from the decision whether the court was of the view that if you had corrected both of them would have been okay. But in the end it said, well, look, you've got the wrong, one of them was still wrong, the resolution's invalid, and the strata had to go back to square one and pass the resolution again. The other issue that arose is that the meeting location was changed at the 11th hour. And there's some hint that this might have been so that the members of the loyal opposition could not find the meeting. That's not entirely clear. That's just my conspiracy theory review of the case. What they did, though, is that they posted just notes in the building saying, oh, the meeting's been changed from here to there. And the court said, you can't do that. If you're going to change the location, you have to actually give notice the same way you would have given everyone of the meeting. Now, the decision doesn't talk about whether you need to start the 20 days over again. In my opinion, I don't think you need to. But certainly if you emailed the notice or slipped it under everyone's door, if you're going to change the location, you have to send that notice out that way. You can't slip a little note on the garbage room door and expect people to find it and show up. The other very important and interesting point of the case dealt with proxies. So there were some proxies that were problematic, and Mr. McDonald raised issues with those. The one thing that I've seen more and more over the years, particularly with the CRT, if you don't like an outcome, attack the process. That way you don't have to worry about the substance of the outcome. If you can attack the process, you can knock it down. So there were some proxies that were problematic, and the court made some directions with respect to how those should be treated at the next meeting. So some of the things the court said with respect to proxies are that Blank proxies are invalid. So if someone were to show up with the proxy signed by the owner but no name, that proxy is invalid and it can't be accepted. The other was that proxies must identify an individual proxy holder, so you can't just put a council member. You have to actually name Bob or Mary or Sue or whoever it is in that position. Also raises the question whether you could even say the president. In my opinion, you can't. It should be the actual name of the president. The other is that the proxy name needs to be written or typed in before the proxy is signed. You, of course, won't know that when you're signing them in, but if that person shows up with the blank proxy, you can't just let them wander off and magically come back with a filled-in proxy. If it's presented blank, it's invalid. Unless the next subcondition is met if the change is initialed by the owner. So if it happens to be an owner who's in the building, they can run upstairs, they can get it initialed and come back, that would be fine. This second to last requirement also pertains to if an owner's given someone a proxy, that proxy holder can't show up. They can't just hand it off to someone and have that person strike out their name, insert their name. It's a change that has to be initialed by the owner. And they must also be signed by hand or digitally. So in other words, you can't just print in someone's name, or you can't have an email that doesn't have a digital signature to it. Yeah.
Email and a digital signature.
So there is an Electronic Transactions Act. So if I recall correctly, it's Saturday morning, so my memory of that act is a little fuzzy. If you had like a regular signature block, or if you signed like documents like e-sign programs and things where you digitally sign, but if you if I just sent an email and said, I give you my proxy, Sean, that's not necessarily a signature. If it came from my office with my regular signature block on it, that would likely qualify. So you have to be careful. A lot of it, I think, is just verifying the integrity of the proxy. There's a question at the back.
So in other words, when it comes to signature and writing the name, the owner should write the name, sign, or if the person writes their own name, the owner should initial that name.
Correct.
Thank you.
Yes.
Is the council or whoever supposed to keep the proxies or hand them back to the person?
That is a diverse view. I think most of my colleagues would say you have to hand them back. I beat to a slightly different drum on that. I think the Strata has the right and should keep them because if someone's showing up, particularly now where you're getting into disputes about process, if someone's showing up, hand it over, say I have the right to vote in respect to Strata Lot 1, the Strata needs to have a record of that. And I'm sure my colleagues can share if they have the basis for if they have a different view.
Why not? I'll stand.
Okay.
I'm not sure I have a different view, but I do agree that it's not a document referenced in the Strata Property Act. Strata Corporation must keep. But on the other hand, with more and more disputes, why not have the evidence that you need to deal with that dispute, if at all possible? But again, Sean's right, it's a diverse among the Strata legal bar as to whether or not you keep them, because it's not a document that the Act refers to.
Assuming you were going to keep them, for what length of time? At what, because property management firms don't want to stack the paper forever.
2 years would be my advice, because you have the Limitation Act is 2 years. So if you're going to challenge what happened at that meeting, you would, in most cases, have to do that within 2 years of the date of the meeting. Yes, sir.
Blocking the fence, it's really a contract between the person who's signing the proxy to the other person. But I respectfully agree with your position. Strata needs something. Just take a photo of it.
Yeah.
Then you haven't compromised, you walk the fence.
Yeah, and that's definitely, you don't need to necessarily keep the actual proxy because it may have some instructions to the owner, but my view is you should keep a record of sorts. So I'll take maybe one more question on proxies. You can. So there is no mandatory proxy form. There's a suggested one in the Act, and it has a variety of different things. It has a proxy for general, for a meeting, for a specific resolution. And so that's where if you are if you have a proxy that has instructions, that's why, to this gentleman's point, the owner needs it, so they need to be able to follow it through the meeting. I'm just going to move us on to keep us going. I'm happy to chat about during the break about proxies if any of you have questions. Oh, okay.
On your first point about the court saying that the notice must be balanced in the views it presents, that implies that the council would be aware that there are negative views in existence. What is the onus on council to canvass any issues that are about to be on an AGM as to whether or not there are divergent views?
Right. The court didn't actually discuss that. In the case, it was clear that Mr. McDonald had an opposing view. So I don't think that there is an onus to canvass everyone, but certainly if there is a no in opposition, you'd need to take that into account. The other important thing the case dealt with was the conduct of the chair. So Mr. McDonald, as you can imagine, wasn't the favorite of the Strata Council. And one of the things the court said, made this observation: an owner addressing council on an issue concerning the Strata Corporation has a reasonable expectation that he or she will be heard, treated with respect, and that his or her concern will be considered by council. Now, the court said addressing council. This was in the context of the meeting, and I think the judge referred to council because the president was chairing the meeting. But this applies the same when addressing the ownership at a meeting. This is the expectation the court said. People need to be given a reasonable opportunity to speak their mind and say their view, even if you, as the chair or the council, don't like that. It is a democracy. As Churchill said, democracy is the worst form of government except for all the rest. That applies to Strata AGMs at times. But you need to give people a reasonable opportunity. Now, there are limits to that, and those limits came up in the 2018 AGM, different chair. Mr. McDonald got up and he wanted to recite large sections of the Strata Property Act. Having read it, it's not that exciting. And the chair at that point said, well, look, could you please just summarize them for us? We don't want to be here for 20 minutes while you're reading through it. And he did, and the court found that that was a reasonable restriction on this right to speak. If you don't need to let someone go on and on forever. Yes, ma'am.
So it would be probably fair to say before the meeting, you announce to the audience and the council members that please keep in mind that voice your opinions. That is more than welcome. But please don't get off topic and don't keep repeating yourself, because then for my job as chair, I will have to intervene and
Yes, I agree. I think it's good at the beginning of a meeting to set out some parameters with respect to how speaking's going to work. In the real textbook world, you'd want to pass a motion to approve that. But I think in most meetings, it's fine just to say, this is how things are going to work, so everyone's aware of that and follow a fair process. The next case I'll just take you through is a CRT decision with respect to flooring, how to handle flooring noise. This is becoming more and more of an issue as people are going from carpet to hard surface flooring. It's an important case for two reasons, one of which it gives some guidance with respect to how councils are to handle flooring complaints, and also what the consequences of not handling those are. Just very briefly, the owner above it installed hard surface flooring. Actually, the previous owner had. New owner moves in. Owner below suddenly starts experiencing significant noise to the point, she said, where she couldn't sleep, relax, watch television, basically live her life. The strata manager got involved and said what often strata managers and councils do in these cases. There's nothing they could do about it. They're within their rights, and suggested that the owners deal with it between themselves. The CRT said that's not the way to go. A little bit more of the there's to come inspect the unit. The owner below was reluctant to allow the council member in, only because they weren't sure what the test was going to be, what's the purpose of this, how are we going to get a resolution. Council answered that question. She then requested a hearing seems to be because the council member who she was dealing with never passed the request. But nonetheless, it was a valid request that was never fulfilled. After the claim was filed, the strata manager came in, did some testing, made some conclusions that the owner had a legitimate complaint about squeaking and creaking noise, and then made some recommendations about tearing apart the ceiling from the owner below and doing some work there, which of course Ms. Turok was not thrilled with by any stretch. The CRT looked at the case, held that the owner's noise complaint was legitimate based on the strata manager's findings. In other words, the fact that there was annoying creaking noise constituted unreasonable interference and a nuisance. Also noted, interestingly, that there's no requirement that noise reach a certain decibel level in order to be considered unreasonable or a nuisance. So that's often the discussion, well, let's do a decibel meter reading, that'll determine with respect to whether it's unreasonable or not. And the court said, or the CRT said, there really isn't a test for that, it's an objective test. The other thing it said is that the owner below is entitled to live without frequent exposures to annoying noise. It recognized that the owner below has some rights to quiet. You can't simply say, well, we allow hard surface flooring, or you live in a strata, you bought the unit below, that's life. The CRT said there's an expectation that owners have to live without that annoyance. It also considered the strata manager's proposal speculative and wasn't based on, and that it wasn't based on any expert examination, or it was just that we're going to try this and hope for the best. So what did the CRT order the strata to do? It ordered the strata to hire and pay for a structural engineer to investigate the source of the noise and come up with some recommendations. And if you read the decision, my guess is that's what the CRT thinks the strata should have done in the first place. So you'll go back to the CRT held that the strata had a duty to investigate the complaint, and I think this is what the CRT meant by that, is that the strata needs to get involved, hire an expert, and have a look at it. Also, once the source of the noise is identified, the strata has a duty to do what's reasonable in the circumstances to reduce that. The other interesting, and I guess one could say scary part of the decision is that they ordered the strata to pay the owner $4,000 for the inconvenience that she endured. And this is part of a trend that the CRT's starting, is to penalize stratas where the owner has either been inconvenienced or their rights have been interfered with in a way that is significantly unfair. So there's a couple decisions where owners have not been granted hearings, and the CRT has said that strata needs to pay the owner, $1,000 for significant unfairness. So this case, in my view, is important. It shows a trend towards investigating flooring complaints. There's 3 or 4 cases that follow it that reach a similar conclusion, and also the penalty aspect. If you're not doing what you should be as a strata, you're going to be liable to the owner.
So your middle, well, that doesn't imply that the strata corporation had to pay for the reduction in the elimination?
Not necessarily, because they didn't know what it was. There is another case. There is another case that follows this where they did order the strata to actually undertake the work. So take that with a grain of salt. It could be that the strata ends up having to do it. Sorry, in the back.
Would it be reasonable to have something created so that this doesn't happen in the bylaws, that if somebody wants to change out their flooring, that it has to be inspected prior to, and that they have to send in what their process and what materials, who's going to be the installer, all that information prior to it being done for the protection of?
Certainly, the more comprehensive your bylaw and approval regime is, the less likely is there's going to be complaints. That doesn't necessarily mean that there won't be complaints that you have to deal with. But the more that you can do to make sure it's properly installed and limit the noise, the better chance you have that the strata is not going to have to be involved in this. I think there's one more question at the back I'll take.
I was basically the same, what I was going to say, basically the same, but they have to get any type of renovation that they do within their unit, should be approved by the council. Just the fact that if they're doing plumbing, the flooring, electrical, we need to know if it's done in a safe, professional manner. And also to let them know of the name of the business. Some places, they have this liability clause, but they don't enforce the name of the business.
Right. Yeah, no, definitely it's important, no matter what you're doing, to have some oversight. You might have lawyers that want to try plumbing, and that probably won't work that well. All right. Okay, one last question, then I'll turn things over to Matt.
So they took the carpeting out. We do have that bylaw, and it is an indemnity clause you must sign. If they didn't contact Strata, they took the carpeting out. Now he sold the place. Now, all of the complaints below, can we as Strata do anything about forcing the issue to get carpeting put back down?
A new owner who takes over inherits the issues from the previous owner. You may not be able to find that owner because they didn't breach the bylaw, but they still have an unauthorized alteration. The new owner is going to have to deal with that. So if it means taking that up and doing whatever needs to be done, that still falls to the new owner.
Putting the carpet back down, do we have the right as Strata?
Well,
when he didn't
that
sign the indemnity clause?
that again is getting into a specific situation about your bylaws. But I can say the new owner inherits whatever problems were left from the old owner and unauthorized.